Today on Judge Faith, it's a case of renter's remorse when the home this couple fell in love with turned out to be a stinker.
And it was just like this wave of this horrible odor.
You had an opportunity at any time to say, fix this, do this. I got $3,600 and he got a lease. That's the deal, right?
Mr. Wagner, calm down.
And later, this mother co-signs a car loan for her son's wife, as long as they both shall pay.
They were married at this time when the orange slips started coming, lime green, bright yellow. They didn't let me know.
Told me about.
Y'all were married at that time, so you both saw them.
No, I did not. Listen, I'm gonna tell you this right now. She doesn't care.
Faith Jenkins. Her distinguished legal career began when she graduated first in her law school class. She quickly became a tough New York City prosecutor, and then a preeminent legal analyst on cable news. And now she's the judge in her own courtroom. Her cases are real, and her rulings are final. She is Judge Faith. Plaintiff Gary Coleman is suing a would-be landlord for the return of his security deposit on the home he never moved into for sanitary reasons. He is joined today by his wife and witness, Nancy. Defendant David Wagner denies the rental was unfit to live in and wants to be paid for the time his property stood empty while he found another tenant.
Remain seated and come to order. Court is now in session. The Honorable Judge Faith Jenkins presiding. Your Honor, this case is Coleman versus Wagner.
Thank you, Barbara. Okay, Mr. Gary Coleman.
Yes.
You were suing the defendant David Wagner for $450, the return of a partial security deposit?
Yes, that's correct.
Okay, and you have a witness with you today?
Yes, I do.
Who are you, ma'am?
Nancy Popovich Coleman.
Okay, and how do you know the defendant, and how did you come to pay him this security deposit that you're trying to get him to return?
We were looking to rent a house. This was back in April of this year. And we saw online that Mr. Wagner had a house for rent in Lincoln, California. The house size seemed right, and the price was right with us too. So
what
we
was the
called him up.
price?
It's $1,800 a month.
Okay. And so you decided to rent this house?
Yes, well, we went to visit with him and saw the house, liked it.
Okay, so he comes over the next day. How many times?
Well, that's not exactly what happened.
Okay, why don't you tell me?
What actually happened is he called and said they were interested in looking at the house. And I said, come and look at it. And I had a financial application that he needed to fill out, and I would review his finances. And based on that, he would be a prospective renter.
Okay.
So I decided that I would rent the house to Gary. And so
did you call him up and tell him that?
I called him and also sent him an email. I think you have the email that said, okay, I've chosen you, but you need to give me the $3,600. Half of which is the rent for the first month and half of which is the security deposit.
So you took him a check for $3,600 and you signed the lease?
Yes, actually what I did is I made one last walk through the house because there were a couple of things that we had questions about.
Well, let me ask you something. The lease is from what date to what date?
It's for 1 year starting May 1st.
Okay, so it's a May 1st lease.
Well, he didn't want us to take possession of the house then.
But you signed the lease for May 1st.
Totally candid here. What was going on was that he wasn't finished with the repairs.
No.
He wasn't ready. Now, he was going to take a couple days
look at the email.
later.
The email says, Gary, you can move in on Friday.
David,
Sir, let him finish and I'll give you an opportunity to respond, okay? Why don't you find the email that you're talking about while he's telling me? Okay, so you're saying that despite you signing this lease that starts on May 1st,
I agreed that we were going to be paying for a couple, 3 days that we weren't living there.
Okay, when does this breakdown happen? You never move into the home.
No, we never did.
And you eventually ask for a refund of your $3,600, right?
Yes.
Tell me about that.
Well, that happened May 1st. On the 30th, when I gave him the check for $3,600, I said, okay, I know that we can't move in, but we need to get ready for the movers. And my wife and I would like to walk through the house again and determine what goes in which room and so forth.
Okay, what happened?
So this is my second time in the house. So we walk in the front door. The first thing we notice is that all the windows in their house are left open. The last room that we entered into, Gary walked in there first, and I followed him in. He asked me if I smelled anything, and the only thing that I could smell was like a juicy fruit, tropical sort of a scent. And I realized then that I was standing right next to a plug-in air freshener. So I stepped away from that and took a couple of deep breaths, and there was this awful odor that I know is cat urine. So Gary and I decided we were going to leave the house. We shut the windows. shut the door to that bedroom.
We took out the air fresheners too, which was very important.
Why were you doing that?
So that we could leave the house for a few hours and then
see what it would smell
see
like
what it
when
would
you
be
went
like.
back. Okay.
We returned the key under the mat. And when we came back, the first place we went to was the bedroom that we're talking about. We opened the door and we walked in, and it was just like this wave of this horrible odor. Of course it was worse because it was a warm day. Now the windows were all shut, and it was not good. I mean, I don't know how anybody could live in that house.
So you go to him and you say, deal's off. I want my money back, $3,600.
We called him from the house, and we told him we were not going to rent it.
Okay, so I'll let you respond to that.
Well,
Was there an issue with cat urine?
no.
You
Gary,
even told-
you
you
say
told me
there's
about
cat
the cat.
urine. You had an opportunity at any time to say, fix this, do this. And the lease that you signed says the tenant acknowledges he's examined the leased premises, and the acceptance of this agreement is conclusive evidence that the premises are in good and satisfactory order.
And that's the issue.
and he
because you
signed
signed the
it.
lease. Okay,
He keeps
all right.
talking about a signed lease.
Okay,
He
I've
doesn't
heard
have
enough.
a signed lease
I've heard
from
enough.
us. There is
Tell
no
me,
lease.
why do you say there's no lease? Because I do have a lease here
That's
with
the only copy.
signatures.
That's it.
Well,
And
that's
I
all
never
you need
signed-
is one
And
copy.
she never
I never
signed
signed
it.
it.
But you signed this lease.
I did when I gave him the $3,600. I didn't know about the
If
problem.
you don't have a lease, then give me my $3,250 back because you just gave me money.
But that lease is not
Because
valid.
if you
Hold on a
if
second,
you don't
hold
have a
on a
lease,
second.
then you just gave me some money, Gary. There's only one reason you have a lease.
Mr. Wagner,
Well,
Mr. Wagner, calm down.
Coming up, this rental catastrophe comes to a screeching conclusion.
So you returned all of their money except for $450. Why'd you keep the $450?
And later, Judge Faith takes the driver's seat in this clash over car payments.
If you lose your job, yes, it's a problem, but it's not her problem.
Plaintiff Gary Coleman wants all his rental deposit back on a home he never moved into because of the smell. Defendant David Wagner wants to keep some of the deposit to pay for the time his property stood empty.
So here's what happened. You signed the lease, your wife signs the lease, and you sign it.
I signed it.
You give him $3,600 deposit and first month's rent. You don't sign it.
Correct.
And it's your position that because she didn't sign the lease, it was never really a binding contract.
Yes.
So you returned all of their money except for $450. Why'd you keep the $450?
when he said he didn't want the house,
It was May 1st.
yes.
And so that was too short of a time period for you to get someone else in there
So
at the
I
beginning of
called
the
the
month.
person that I had called before. He said, we want the house, we love the house, but probably it's going to be the 15th.
So you prorated those days
So I
that no one
basically-
was in the home, and
I
you kept
basically said
$450.
I lost 2 weeks' rent, which is $900.
Mm-hmm.
And I said in the letter, Gary, I'll just split it with you. And the only
And why do
reason,
you think that's not fair? I know you're saying technically your signature isn't on there,
Well,
but
he was-
here we clearly had a meeting of the minds in terms of a contract. Money
We
was
had-
exchanged. We have signatures
And
here.
also
It's a
he-
done deal.
and he
Don't
got the
interrupt me
keys.
right now.
But he got the
We have a
keys.
meeting
He
of
took
the minds.
possession.
We do not have
Judge
keys.
Faith
Never had
did not have the
keys.
keys.
Why do you think it's unfair for him to keep just $450 when he did have this gap in time where no one was there because he relied on the fact that you were going to move in?
Okay, first of all, he would not rent us the house unless both of us signed the lease. He was emphatic that both parties had to be in the lease.
Here's the issue, sir.
But
I understand you're
that's
saying her
one thing,
signature
okay.
isn't there, but what I'm telling you is there is clearly a meeting of the minds here in terms of entering into a contractual agreement. So a couple of times people have changed their
But Judge
minds
Faith,
here.
there was no disclosure that there was a horrible odor in that home.
Well, here's the issue about disclosure. You have to prove that he intentionally tried to hide something from you. I understand your position, but I don't know if that's the case. People have pets that live in homes and you have to air them out before someone else moves in. You walked through the house twice, and I know you said the windows were open, but you have to do your due diligence. And what I think is reasonable, listen, if we were here and he kept all $3,600, it would be a very different scenario. But he didn't. He returned all of that money back to you, except the days that he didn't have someone in there because you pulled out at the last minute. I just think it's
Your Honor?
it's
And I
fair
even kept-
and
gave him back
equitable.
half of
No,
that.
let me finish. In terms of doing what's fair and what is equitable, when a landlord rents a property and leases a property and you pull out on the agreement, they have to then go and find someone else and they lose money. So the
But
fact
then,
that he
Your
lost
Honor-
don't interrupt me, the fact that he lost $900 and he's willing
But he
to
did
split
not.
that with you for $450, I think that's fair. Verdict in this case for the defendant. Good luck.
Plaintiff Gussie Brooks co-signed a car loan for her daughter-in-law. Now that her son's marriage is over, Gussie is suing for delinquent car payments, unpaid toll tickets, and emotional damage. Defendant Lysandra Scott claims she has a perfectly good reason why she didn't pay for the car, and she's countersuing for pain and suffering caused by the plaintiff.
Court is now in session. The Honorable Judge Faith Jenkins presiding. Your Honor, we have Brooks versus Scott.
Thank you, Barbara. Gussie Brooks,
Yes, Your Honor.
you are suing the defendant, Lysandra Scott, for $6,500. You say she owes you for car payments, toll road tickets, and for emotional damage?
Yes, Your Honor.
And you understand the statutory maximum in my court is $5,000?
Yes, Your Honor.
And you are countersuing, ma'am, for $1,500 for pain and suffering?
Yes.
Okay. How did the two of you know each other?
She was married to my son for a couple of years.
What years?
Since 2008. And our divorce was finalized in 2011.
Do you remember what month?
In August.
Okay. And so you say that you co-signed for a car with your son and that this car was for the defendant to drive.
Yes.
Okay, tell me what happened.
She couldn't qualify on her own, and the dealership, they asked us to co-sign together. Maybe we could qualify.
Okay, so you and your son co-signed for the car, correct?
Yes.
Do you remember what year this was?
2007.
Okay, so they were still married.
Yes.
All right, so the two of you co-signed for it, and what was the agreement in terms of who would pay for the car?
We agreed that we would co-sign, but she would have to pay for the car.
Was that the agreement?
Correct.
And was the
But
car
they-
note in your name?
No, my name is nowhere on the car.
Okay, but the agreement was you would make the notes.
I would make the notes,
And this
yes.
would be your car for the most part?
It was our family car.
Okay,
Yes.
do you have kids together?
Yes, we
How
have
many?
3 children.
Okay, and does he help support them?
Correct.
He does?
Yes.
Even though the two of you are divorced, he does pay child support?
No, I had the kids for the first 2 years. He's had them for the last 2 years. And then we rotate the weekends, and through the summer, he has a week and then I have a week.
Okay, so you agreed to pay the car notes on the car, and that went fine all the way up until when?
Till like 2009 or 10, because she did pretty good for about 3 years, and then she just let it go.
Okay, so if your son co-signed for the car and they're married, then that car is considered, and you're from Texas, right?
Correct.
Yes.
So that car is considered to be a community property. So as long as your son was married to her, he is as responsible for those debts as she is. Now, when you and her son divorced, what was the agreement between the two of you as to what would happen with the car?
There was no agreement. I had the car. I mean, it was nothing that we agreed upon. Since it was my everyday drive car, I continued to drive the car after we separated.
Okay, so it was just an understanding that you would continue to keep the car and continue to pay the notes on the car?
Correct.
Okay, so at this point, you're responsible for paying for the car notes. And then something happens and you said you can't afford to pay for the car anymore.
I lost my job.
When was that?
It was 2011. I asked them to get the car refinanced. I asked her when she moved back from California to Texas, I asked her if she wanted the car. When her son's car broke down twice after we separated, I asked him to take the car. He did not take the car. She did not want to take the car. I asked her to get it refinanced. I asked her to get it out of her name. They refused to comply to anything that I was requesting. And after a while, I just called the loan people that gave us the car to just come and pick it up, and I let her and him know that I was getting them to come and get the car because I could no longer afford it.
Okay, so the car was repossessed.
Correct.
Why did you not want to transfer the car into her name?
Your Honor, when she could no longer pay for the car, the creditor started calling me. And at that time, the car was $10,000.
Okay, there was still a $10,000 loan on the car.
left on the car. So I couldn't pay $10,000. So what I did was I waited those years in between so that total amount would go down. So it came down to about $4,000.
And so there was $4,000, as I understand it from your papers, there was $4,000 outstanding on the loan after the car was repossessed.
And they sold it.
And
Yes.
the loan company sold the car, but you're responsible for the $4,000, and you and your son had notes created so you could pay that $4,000 debt.
Coming up on Judge Faith, who pays for the pain?
My
So what
purse
was the
was
issue?
stolen, and of course my credit card got stolen.
Okay, so how is that her fault?
Plaintiff Gussie Brooks wants her ex-daughter-in-law to pay for her own car, unpaid toll tickets, and emotional damage. Defendant Lysandra Scott is countersuing for pain and suffering caused by the plaintiff's collection methods.
Why didn't you help them and make those payments if you agreed to pay for the car?
I couldn't do anything. I'd call up to the loan officer people and see what it was that I had to do to get it refinanced, what I had to do to get it out of. Of course, I would have to call and pretend I was Gussie, and she was aware of this because she gave me the last 4 of her social to do so, because they would not speak to me on the phone.
Well, she's not suing you because she's saying you're behind on the payment. She's suing you because when the car was repossessed.
Well, she was saying that I didn't pay for the car, but I paid for it all while it was in my possession.
When the car was repossessed, there was still an outstanding loan of $4,000, and she's saying she shouldn't have to pay for that. If there's an agreement between the two of you that you would pay for the car, here's the issue. If you lose your job, yes, it's a problem, but it's not her problem.
Yes.
So I understand you say you lost your job and you couldn't afford to make the payments, but you essentially abandoned the car, letting it get repossessed and exposing them to $4,000 in liability. That's essentially what happened. You also said that she had over $1,000 worth of tolls that she got when the car was in her possession. Toll charges?
She had probably cut her card off so they couldn't take the amount for the tolls out.
What kind of card?
I didn't cut my card off.
What
My
was
purse
the
was
issue?
stolen, and my card, of course, my credit card got stolen. So I got a new card. And of course, if you have something auto-debiting out of your account, I didn't realize that it was no longer debiting out of my account.
Okay, so let me understand this. When your credit card was stolen, you never replaced that credit card in the system with a new card.
Right.
Okay, so how is that her fault? Tell me about your counterclaim for pain and suffering.
She's called my phone several times. She's got sheriffs and stuff trying to come up to my job.
That's not true.
It is true. They call my job on a daily, telling me that they need to come up there, or I need to come down to the Urban Police Department to pick up some certified paper that they have to hand deliver me.
So the basis of your pain and suffering is them trying to collect the debt they believe you owe them.
And the last couple of months that I had the car that I was not working, I had to borrow money to make the payments after repeatedly asking them to get it refinanced or get it turned into my name.
Okay.
And I had to pay all that back, so.
Do you have proof of the payments you made on the loan after it was repossessed?
Yes.
May I see that, please?
And Your Honor.
Yes, ma'am.
Once it got to warrant status, they didn't bother to bring me the orange and
Once it got to
lime
what
green-
status?
Warrant status. I had to pay myself out of warrant status so I wouldn't go to jail. They were married at this time when
Right.
the orange slip started coming, lime green, bright yellow. They didn't
That
let
no one
me know.
told me about.
Excuse me?
That no one told me about.
Y'all were married at that time, so you both saw them.
No, I did not. He didn't show me that information.
Listen, I'm going to tell you this right now. She doesn't care. Okay? I mean, it's like
She's
really
arrogant.
obvious right now. You owe this money and you don't care. I get it. I understand it. But just stop with the attitude.
And now, Judge Faith rules.
You paid $2,926 towards this $4,000 loan. I'm assuming your son paid the rest, but I'm going to order her to pay you $2,926 towards the $4,000 loan. In addition, I'm going to order her to pay you the amount of the unpaid toll road bills. And you don't deny that you incurred these charges, and you not knowing that these charges were being made on your credit card is not a defense, because if you really in good faith wanted to pay it, you would have paid something by now before coming to court today.
Well, I asked her for her bank account information to deposit money into her account.
Give her the cash.
I was scared of what she'd do with the cash.
Okay, you're just making up excuses right now. The total you owe her for the car loan payments, in addition to the unpaid toll road bills, $4,273.37. Your counterclaim is dismissed for obvious reasons. I don't find that them calling you to try to collect a debt is sufficient for you to warrant pain and suffering damages. So my verdict in this case is for the plaintiff, ma'am. I'm ordering the defendant to pay you $4,273.37. Good luck.
If you or someone you know has a dispute, don't take the law into your own hands. Let Judge Faith rule on it for you. To submit your case, go to judgefaith.com and tell us your story. See you in court.